Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and today we start the topic of the SAT Procedure Rules 2000. These are the rules governing the procedure of the Securities Appellate Tribunal and it is the SAT Procedure Rules 2000, right? So it is part of your security laws. We have already covered all the acts that formed a part of your security laws and now we start with the rules and the regulations, and today we will be dealing with the SAT Procedure Rules, right? So we are not going to leave even a single rule or regulation that has been mentioned in your syllabus. We will be dealing with each and every one of them, right? Because I have been telling you this, that 40% weightage has been given to the security laws, which is huge, which is very important for your examination. So because of this 40% weightage, each and every act and each and every regulation and rules, they become extremely important. So that is why we are not going to leave anything, right? So we will be dealing with the SAT Procedure Rules of 2000 today. Alright. Before I start, I would like to tell you that EduTap has come up with two courses for phase 2 examination, right? The first one being the test series. Test series, they are going to be very helpful for your preparation. In this, you get chapter wise tests. So for every act, for every subject in your syllabus, the chapters have been divided, and on the basis of the chapters, these tests they have been prepared, right? So you get separate test for each and every chapter that has been mentioned in your syllabus, being it for IPC, being it for the Criminal Procedure Code, or being it for any other act, for example security laws or the company laws, right? Also you get the full length test with evaluation. This evaluation, it will be extremely helpful for you this time because the descriptive part, it has been added by the SEBI for the first time, and on this descriptive part you get evaluation. So an expert is going to be allocated to you and he is going to evaluate your answers and give you any feedback if required, right? And the last one is one-on-one mentor support. So you get one-on-one mentor support in test series also. And for the live crash course, the classes, they have already been started. You get live classes on each and every subject, on each and every act and each and every rule and regulation. So we are not going to leave anything. We will be covering everything that is important for your examination. We are only going to deal in with the questions which are important from the viewpoint of your syllabus, right? Then you get short notes. They will be helpful for your descriptive writing. So please make sure that you are preparing for the descriptive part this time very carefully. Then you also get the test series. All the features that I have just mentioned about the test series, they are also included in the live crash course, and again you get one-on-one mentor support. So we are running a limited time period offer. Make sure to avail it. So if you want to avail it, you can refer to the link in the description below. Now let's start with our lecture. It's question number 1. Every appeal shall be filed within a period of days from the date on which a copy of the order against which the appeal is filed is received by the appellant. So the answer to this question is option C, that is 45 days, right? Let's read this. So every appeal, it shall be filed within a period of how many days? It will be filed within a period of 45 days. From the date on which a copy of the order against which appeal is filed is received by the appellant. So it is how many days? It is 45 days from the date on which a copy of the order against which the appeal is filed is received by the appellant. So when the appellant received the copy of the order, from that day it will be counted how many days? It will be counted for 45 days. He gets a time period of 45 days. Question number 2. A memorandum of appeal sent by post shall be deemed to have been presented in the registry on the day it was posted by the appellant, received in the registry, hand delivered by the appellant, either A or B, none of the above. So the answer to this question is B, that is received in the registry. So rule 4, form and procedure of appeal. A memorandum of appeal, it shall be presented in the form by any aggrieved person in the registry of the appellate tribunal within whose jurisdiction his case falls, or shall be sent by registered post addressed to the registrar. A memorandum of appeal sent by post shall be deemed to have been presented in the registry on the day it is received by the registry. So on the day it is received, it will be deemed that it is presented in the registry on that day. I hope this is also clear to you. Moving on, question number 3. The proceedings of the appellate tribunal shall be conducted in any of the language as under: English, Hindi, English and regional language, Hindi and regional language, English and Kannada, Hindi and Kannada. So the answer to this question is option A, that is English and Hindi. It has been provided in Rule 6, Language of the Appellate Tribunal. The proceedings of the Appellate Tribunal shall be conducted in English or Hindi. So it can be either English or Hindi. No appeal, application, representation, document or any other matter contained in any language other than English and Hindi shall be accepted by the SAT unless the same is accompanied by a true copy of translation thereof in English or Hindi. So if any application or any representation or any document, it has to be filed which is in any other language, in that case a true copy of translation into English or Hindi, it has to be accompanied. Otherwise it will not be presented before the SAT, it will not be accepted by the SAT, right? So no appeal, application, representation, document or other matters contained in any language other than the English or Hindi shall be accepted by the Appellate Tribunal unless the same is accompanied by a true copy of translation thereof in English or Hindi. Question number 4. Registrar under the Securities Appellate Tribunal Procedure Rules 2000 means. So the answer to this question is option B, Registrar of the Appellate Tribunal. It has been given under Rule 2I of these rules, right? So registrar means the registrars of the Appellate Tribunal and includes an officer of such Appellate Tribunal who is authorized by the presiding officer to function as a registrar. So he has been authorized by who? He has been authorized by the presiding officer to function as a registrar. Alright, question number 5. The appeal filed by the appellant should be presented and how many sets in a paper book? So the answer to this question is 5, that is option number C, right? Let's read it. This is appeal to be in writing. This is Rule 7. Every appeal, application, reply, representation or any document filed before the appellate tribunal shall be typewritten. It will be typewritten, printed neatly and legibly on one side of the good quality paper of foolscap size in double space, and separate sheets shall be stitched together, and every page shall be consecutively numbered and filed in the manner provided in sub-rule 2. It is just a mere procedure that has been provided here, right? 2. The appeal under sub-rule 1 shall be presented in 5 sets in a paper book along with an empty file size envelope bearing the full address of the respondent. So this is how many sets? It is 5, right? So that is why the answer was 5. Address of the respondent, and in case the respondents are more than one, the sufficient number of extra paper books together with the empty file size envelope bearing full address of each respondent shall be furnished by the appellant. Question number 6. If the appellate fails to rectify the defect within the time allowed under sub-rule 3, the registrar may, by order and for the reasons to be recorded in writing, decline to register such memorandum of appeal and communicate the order to such appellate within dash days thereof. So the answer to this question is C, that is within 7 days it will be made. The communication will be made within 7 days. Let's read this rule as well. So it is presentation and scrutiny of the memorandum of appeal. The registrar shall endorse on every appeal the date on which it is presented under Rule 4 or deemed to have been presented under that rule, and shall sign endorsement. If on the scrutiny the appeal is found to be in order, it shall be duly registered and given a serial number. If it is duly registered, then it is going to be given a serial number. But in case there is any defect, in that case what is going to happen? So if an appeal on scrutiny is found to be defective and the defect noticed is formal in nature, the registrar may allow the appellant to rectify the same in his presence, and if the said defect is not formal in nature, the registrar may allow the appellant such time to rectify the defect as he may deem fit. So if it is a formal defect, then the registrar is going to allow the appellant to there and then rectify it. But in case it is not a formal defect, in that case he is going to give some time to that appellant. So he is going to give him some time to rectify that defect, right, as he may deem fit. If the appeal has been sent by post and found to be defective, the registrar may communicate the defects to the appellant and allow the appellant such time to rectify the defects as he may deem fit. If the appellate fails to rectify the defect within the time allowed in sub-rule 3, the registrar may by order and for the reasons to be recorded in writing decline to register such memorandum of appeal. So the registrar can decline to register such memorandum of appeal if the appellate has failed to rectify the given defect in the specified time, right? And communicate the order to the appellate within 7 days thereof, and it will be communicated to the appellant within 7 days. An appeal against the order of the registrar under Rule 4 shall be made within 15 days of receiving of such order to the presiding officer or in his temporary absence to the member authorized under Sub-Rule 2 of Rule 5 whose direction thereof shall be final. And if the appellant he wants to file an appeal against this Sub-Rule 4 that we have just read, in that case he has been given 15 days time period and he can file such an appeal before who? Before the presiding officer or in his absence to any member authorized, right? So let's read this again. An appeal against the order of the registrar under Rule 4. If an appeal has to be made, it shall be made within 15 days of receiving of such order to the presiding officer, where it will be made to the presiding officer, or in his temporary absence to the member authorized under Sub-Rule 2 of Rule 5 whose decision thereupon shall be final. And then the presiding officer's decision, it is going to be final on that matter. Question number 7. What shall be the fees payable in respect of the appeal against adjudication order made under Chapter 6A of the Act if amount of penalty imposed is less than rupees 10,000? So the answer to this question is option B, that is rupees 500. Let's find out the fee. Let's read the explanation. This is Rule 9. Every memorandum of appeal shall be accompanied with a fee provided in Sub-Rule 2, and such fee may be remitted in the form of cross-demand draft drawn on any nationalized bank in favor of the Registrar, Securities Appellate Tribunal, payable at the station where the registry is located. The amount of fee payable in respect of the appeal against the adjudication order made under Chapter 6A of the Act shall be as follows. What is going to be the scale? Let's find out. So this is amount of the penalty imposed on the fee payable less than rupees 10,000. Then if the fee payable is less than 10,000 rupees, then the penalty is rupees 500. Rupees 10,000 if the fine is rupees 10,000 or more but less than 1 lakh, then the penalty payable is 1200 rupees, and if it is rupees 1 lakh or more, then it is rupees 1200 plus rupees 500 for every additional 1 lakh of penalty or fraction thereof, subject to a maximum of 1,50,000 rupees. Amount of fee payable in respect of any other appeal against an order of the board under the Act shall be rupees 5,000 only. Question number 8. The party to appeal can inspect the records of a pending appeal on payment of a fee of rupees dash per hour, subject to a maximum of dash rupees. So the answer is option A, that is 20 and 100. So let's read the explanation. This is Rule 22. A fee of rupees 20 for every hour or part thereof of inspection, subject to a maximum of rupees 100, shall be charged for inspecting the records of the pending appeal by the party thereto. A fee of rupees 5 for a folio or part thereof not involving typing, and a fee for rupees 10 for a folio or part thereof involving typing statement and figures shall be charged for providing copies of the records of an appeal to a party thereto. Right, let's move on. Question number 9. The party to the appeal can obtain copies of the folio or the records or part thereof of a pending appeal on the payment of the fee of rupees dash per folio not involving typing, and a fee of rupee dash for a folio or part thereof involving typing of the statement. We have just read this in the previous question. So the answer is 5 and 10, that is option B. So it is a fee of rupees 5 for a folio or a part thereto not involving typing, and a fee for rupees 10 for a folio on part thereof involving typing of a statement and figures shall be charged for providing copies of the records of the appeal to a party thereto. Alright, last question, question number 10. Functions of the registrar have been mentioned in which rule? The answer to this is option C, that is 25. It is Rule 25. Let's read this. The registrar shall discharge his functions under the general superintendence of the presiding officer. So the registrar, he is under the superintendence of the presiding officer, or in the temporary absence of the presiding officer, the member authorized under sub rule 2 of rule 5. He shall discharge such other functions as are assigned to him under these rules by the presiding officer, or in the temporary absence of the presiding officer by the members authorized under sub rule 2 of rule 5 by separate order in writing. So he is going to discharge any of those functions that have been assigned to him by either the presiding officer or the person authorized by him, but it has to be in writing in case of the member authorized, right? What are these functions in particular? He shall have the custody of the records of the appellate tribunal. The official seal of the appellate tribunal shall be kept in the custody of the registrar, subject to any journal or special directions by the presiding officer, or in the temporary absence of the presiding officer, the member authorized under sub rule 2 or rule 5 of the official seal of the appellate tribunal shall not be affixed to any order, summon or other process save under the authority in writing from the registrar. And the last one, the official seal of the appellate tribunal shall not be affixed to any certified copy issued by the appellate tribunal save under the authority in writing of the registrar. If it is in writing by the registrar, then only it is going to be affixed. I hope these questions are clear to you. These are just the simple procedures and I hope you have understood these questions, right? Now question for achievers. If the appellate fails to rectify the defect within a time allowed in sub rule 3, the registrar may by order and for the reasons to be recorded in writing decline the registrar such memorandum of appeal and communicate the order of the appellant within 7 days thereof. This we have done. An appeal against the order of the registrar, it shall be made within how many days of receiving of such order to the presiding officer? This also we have done. I hope you know this answer. So the options are 5, 7, 3, 15 or 20. So you have to comment the right answer below. So that was all for today. I hope it was a helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.